Thank you very much. I would like to start by a sentence that I've learned in the past 18 days. I would like to acknowledge the traditional owners of the land we're gathered upon today and pay my respect to the elders past, present, and future. I'm going to take that back to Canada. That's, I find, very interesting. I feel a bit intimidated. You've been, I'm in front of a group of specialists, and you've been discussing these issues all day, and I come with the little knowledge that I've gathered over the past 18 days, and I'm going to lecture you on what you know better than me. That's a bit intimidating, but I'll give you in part the presentation I made to the Australian authorities this morning in Canberra after these 18 days. So that you understand the process and what I'm doing. As a special rapporteur, and first of all, as was said very aptly, I'm an independent expert. I'm not on the payroll. I'm not representing the UN. I can say things that the UN will contradict tomorrow. I'm an independent expert. I do that pro bono, and it's my personal capacity that I engage only. I'm supposed to do, on average, 2 country visits per year and 2 thematic reports per year, so 4 reports. I report to the Human Rights Council in June. I report to the General Assembly, the Third Commission, in October. And so this, what I've just done is a country visit. It's 18 days. It's a bit more than usual. Usually it's 11, 12 days. But Australia is a big country, so I think 80 days was actually necessary, and I didn't see everything, for sure. What I do on the last day of the mission, always, that's standard operating procedures for special procedures, we do an end of mission statement, which contains preliminary conclusions of what we've seen during the mission, and we give that to the authorities. It's followed by a press conference. There's the release of a press release, and attached to the press release is the end of mission statement. It usually is 5-6 pages. Today it's 10 pages. I imagine I had lots to say. The report comes after. The report is almost precisely 10,700 words, because that's the maximum that we'll have interpreters for. So it's about 22, 24 pages. And it is done over the following months. In this case, it will be done until approximately mid-March. The authorities will get a draft mid-February for comments so that they can have an input on the report. And mid-March, we send it for translation in the 5 other languages of the UN. And it's posted at the end of May, and I present it the second week of June. Well, that's the process we're in. The mission is always organized at the invitation of the authorities of the country. I requested an invitation. Australia has a standing invitation to all human rights procedures, so it was not difficult to obtain the invitation. We find dates, we agree on dates. And it was very well done. I've had great collaboration of the Department of Foreign Affairs and the Department of Immigration and Border Protection in preparing this mission. We organized with them, and in this case it was essentially the line ministry, the Department of Immigration and Border Protection. We co-organized the official part of the mission, the meetings with all the civil servants, the meetings with, the going to the detention centers, going to places where most of us usually don't go because it's, security, etc. So all this is organized with our partners in government. It's either Foreign Affairs or Line Ministry. The other part of the mission is meeting with NGOs, civil society, service providers, media, colleagues, and this is privately organized. The government is not apprised by us of what we do. In some missions, we know that the government knows everything that we do anyway. So what I'm presenting today are the preliminary observations. There might be errors, and there's bound to be errors. We can't, in 18 days, understand everything that's going on. It's quite complicated. And I want to say that I've really had a great cooperation of the authorities And that counts. I've been able to go to first Canberra to meet the authorities there. I met a great number of civil servants of different ministries, different departments who work with migrants. I've been to Canberra, Perth, Melbourne, Brisbane, Sydney, visited 5 detention centers in all those cities, been to Nauru for 2 days. This was organized with the authorities of Nauru, with the help, I imagine, of Australian authorities. And so this was really interesting. I've also met with a great number of civil society people, and that was also very interesting. All in all, I mean, the first point that I made to the authorities this morning is that Australia is a great country of immigration, with a great tradition, with a rich experience, and for many people in Australia, a very positive experience of immigration. Out of the hundreds of thousands of migrants that Australia receives every year, the vast majority of them have a positive experience of immigration. And so that is important, and recent initiatives like increasing the number of refugees to soon 18,750, the number of Syrian Iraqi refugees that was announced, 12,000, out of whom 9,000 have already received a visa and 6,000 have already arrived in Australia. That's quick. That's a quick turnaround for this country, and so that's good. The number of students of temporary migrant worker visa, of working holiday visa, is also huge. And for many, including my daughter, who now lives in Sydney, it's a positive experience. It's something which is absolutely great. And I've been particularly impressed by the energy, the imagination, the determination, the dedication of civil society, and particularly service providers to migrants, those who help migrants integrate. I've met with them in all 5 cities that I visited. I also met with them in Nauru, and there are absolutely great initiatives, people who really care and people who help integrate, and that is very interesting. And it's a contrast maybe with the image that Australia has projected in the past few years about its attitude towards asylum seekers and refugees. There are many people out there who actually care and do and go to great extent to make sure that these people are helped in the best way possible. However, all this being said, there are issues, human rights issues, important human rights issues. The first point I've made was the punitive approach to unauthorized maritime arrivals. It is a punitive approach. It is defined as a punitive approach. The idea is to punish people who come irregularly in order to deter others and to send a message to the smugglers. That's how it's explained. Whether it deters anyone remains to be proven. I haven't really seen. The pushbacks may have probably stopped the boats. I'm not sure that the punitive approach has. It hasn't worked elsewhere. Let's say that. Unauthorized maritime arrivals are treated very differently from air arrivals, unauthorized air arrivals, and that is a distinction which is a discrimination. It has no basis in international law, in refugee law, in human rights law. You know, 2 people claiming protection for the same reason, one arriving by air, one arriving by boat, and the only reason why they're treated very differently is their mode of arrival. Doesn't make sense to me much in terms of principles. Second, the idea of deterring by punishing. You cannot deter Bill by punishing John. That's not how human rights law functions. And that's best expressed in Kant's categorical imperative. Never treat the other only as a mean, but always also as an end. And that's the great lesson of human rights. Every one of us is an individual worthy of respect, of dignity, and having their rights protected. Everyone. And there's no distinction. We cannot punish one to deter the other. That doesn't work in international human rights law. So to me, that approach is flawed, fundamentally flawed. Second, immigration detention. Immigration detention on Australia mainland has been considerably reduced in recent months. It has been important, but it has been considerably reduced. The number of people detained has nothing to do with what it was in the past. So that, to me, is a good thing. Australia has developed alternatives to detention. There is community detention, which is still part of a detention, but people are allowed to circulate, so that's sort of a halfway measure. But many of the refugees and asylum seekers are on bridging visas or other types of visas, and that, to me, is a good way of avoiding detention in detention centers. The problem is with the rule of mandatory detention for all unauthorized arrivals at the beginning. And that, again, this mandatory detention rule, to me, has no basis in international human rights law. Deprivation of liberty is only justifiable if it is legal, necessary, proportional, reasonable, and a measure of last resort for each individual. For that, you need an individual assessment. Making detention mandatory for everyone does not respect those criteria. It leaves no space for considering the particular circumstances and for applying procedural safeguards and allowing people to have access to regular review mechanisms with appropriate legal representations and interpreting services, publicly funded if necessary. That is not in place. Mandatory detention, in that sense, to me, is a violation of fundamental human rights principles. And the majority of people in detention today have been held in detention for more than 2 years. I've met people who were in detention, in administrative detention without charges and having committed no crime for 8 years. The longest, I'm told, has been in detention for 9 years. I've met one who was there for 9 years. You can imagine the damage that does to physical but also mental health. The levels of mental health issues with asylum seekers and refugees in particular is very important, those who are detained. Self-harm, PTSD, anxiety, depression. Many of them are on a daily diet of happy pills in the morning and sleeping tablets in the evening. And that is, and including teenagers, that is an unacceptable outcome when it's engineered by a policy. So and I believe, and I'm not the first one, I've studied quite closely the numbers and the conditions, etc., to see if I would associate myself. But I associate myself to all those, including several UN bodies, who have said that this amounts to cruel, inhuman, and degrading treatment or punishment in international human rights law. I think that the Australian authorities should dismantle the mandatory detention policy and should set a statutory limit in law for administrative detention without charges and without having committed any crime. I recognize that there's need to be some leeway for serious security risks, but not 9 years, not 7.5 years. There has to be a statutory limit of some kind. The issue of children in detention. Thank God, on Australia's territory, I've had 2 statistics. One was that there was 1 child in detention, and the other was there were 4 children in detention. Whether it's 1 or 4, it's too many. We agree on that. But it's quite extraordinary. Australia is the only country I know who has almost effectively implemented the policy of no children in immigration detention. And I'm talking about the mainland. And that is, to me, quite extraordinary. That's really a success. Having done that, and having purposely done that. It was done, there was a policy of getting all these children out of detention. Not many countries have done that. So that's a good thing. I suggested to the Australian authorities that this should be committed to law. There should be a standard written somewhere probably in the Immigration Act, that children are not to be detained and that alternatives to detention must always be found for unaccompanied children and families with children. And this comes from, the 2012 declaration of the Committee on the Rights of the Child, when they said that immigration detention can never, ever be in the best interest of a child. Period. And I'm quite happy to see that this is happening here. But it should be committed to law so that we don't see another surge of detention of children in the future if circumstances happen. However, in the regional processing centers in Nauru, there are a lot of children. And in the settlements outside, but on Nauru, there are a lot of children. And those children are scarred by their experience. Many of them have been in detention in the RPCs, and then when the RPCs were opened, when the family was recognized as refugee, they were in the settlements in Nauru. Although some of them have stayed in the RPCs for safety reasons. Those who are still asylum seekers have to live in the RPCs, although the RPC is open. They can come in and out by signing in and signing out. Those children are scarred. They show signs of, like the adults, PTSD, anxiety, depression. They have insomnia, nightmares, bedwetting. And this is quite across the board. A policy that does that must do something wrong. And that's what I've told the authority. Feelings of hopelessness and frustration. So children have to get out of that environment. Regional processing centers, segueing. I agree with all those who say that Australia is responsible for what's happening inside the RPCs. These RPCs are created at the initiative of Australia, funded by Australia. The personnel is on contract by Australia. This is Australia's taxpayers' money. Australia is responsible. It may also be co-responsible with Nauru authorities. There may be a co-responsibility, but there's no escaping that Australia is also, at least also, responsible and should be held accountable for what's happening there. I'm not the first one to say that. Many UN bodies have said that. Especially due to the fact that it was purposely engineered by Australian authorities as a deterrence mechanism. There was an intent of making it a deterrence mechanism. And considering that, considering the incredible hardship that most of the refugees who are there have endured before arriving in Nauru, and considering that Australia has been put on notice for several years of the problems by civil society, by the UN, I think it's a statement of fact to say that Australia is responsible for the considerable damage inflicted to asylum seekers and refugees, and that, again, the involuntary geographical and psychological confinement, it's not a detention anymore, but it's a confinement on Nauru. You really have the impression of being confined to a very narrow space on the planet. Constitutes here, too, cruel, inhuman, and degrading treatment and punishment. The only solution is to quickly close those centers, and I'll come to that. In Nauru, we must all recognize that the Australian authorities have operated considerable investment to try to increase the capacity of the centers, the services, the quality of the services offered, the capacity of Nauruan authorities to provide health services, including mental health services, to provide education services. There has been a considerable investment in the community. And in that sense, Australia has tried to change the situation. The fact that the RPCs were opened at one point also changed the situation. But the testimonies I received, I talked to many of the refugees in Nauru, stories of despair, lack of information, contradictory information, and especially having been disappointed too many times by rumors and information received that didn't prove right. Mental health issues are rife. Again, sleeping tablets and happy pills, almost for a majority of the population. Australia will have to settle or resettle those refugees. I mean, they can't stay there. And Nauruan authorities are very clear that this is transitory. Now, what's the length of a transition? We talk about sustainable development. We all know that unsustainable situation can be sustained for a long time. And so this should not last. And we hope that this is going to change. There is now talk of an agreement with the US. This agreement has been announced after I had left Nauru last week. There were rumors, but there were only rumors, and there are many rumors. If the agreement leads to many people leaving Nauru, it will be a good thing. But it has to be implemented properly. I understand that I don't have anything more than what you have. I've had a 10-minute briefing with a high-level official about the public content of the information available. So I understand that it is the Australian authorities that are transmitting the file, that the file is approved by UNHCR, transmitted to the Americans are choosing according to priorities. I understand that they will prioritize families with children. And so, you know, and I also understand that it is the intent of all parties to have the first arrivals in the US before Christmas, which is good, which means you know, they kickstart the procedure before, you know, very quickly. The American team is already in Canberra. There is a UNHCR delegation in Canberra. I mean, the forces are there. They want to move fast. No one knows what the change of administration on the 20th of January will do. It may not do much. If the transfer is operated, you know, if, for example, there are 20, 30, or 40 people going to the US every month, it might not even hit the news. These are very small numbers. It may very well be that the new administration will not even, you know, really see it, or will not make a big fuss about it. We don't know. This is all speculation. But certainly it's the hope of everyone that this will be seen through, and that a great number of the people on Nauru and Manus Island will be moved. For those who are not selected by the Americans, Australia has the responsibility of finding other places of resettlement, and if the number is not too high, I can imagine that New Zealand could renew their offer, and I imagine that if there is a small number at the end, Australia could even relent on its promise not to let anyone come. I mean, the idea is to solve the issue. That, to me, is... I'll come back to regional cooperation. Oversight mechanisms. We've been impressed by the number of oversight mechanisms, but we've considered that quite often. For example, the Commonwealth Ombudsman, the reports are not made public, or at least not made public immediately. And it's really an internal oversight, which is done rather than a public oversight. I think that is missing. There is an issue about independent oversight with reports made public on a regular basis. I think, for example, that the Human Rights Commission should be allowed to go to Nauru and Manus Island and do their own assessment. I've been quite impressed with the role of the Fair Work Ombudsman in trying to fight labor exploitation, especially with the temporary migrant worker visas. There's quite a lot of good work which is done. I've noted, however, that there's no estimation no real well done, well calculated estimation of the size of the problem, of the exploitation of students and backpackers and holidaymakers, etc. We don't. There's no knowledge. There's data is missing, and that I think is something that needs to be recognized. It's probably bigger than we think, maybe not as big as we fear, but it will be probably a significant number of people who find themselves in exploitative conditions. I think Australian authorities have to attend to that. And I think Australia should ratify the optional protocol to the Convention Against Torture and establish the independent national preventative mechanism that it provides for. Access to justice, equality before the law. I think here, on immigration issues, Australia has a big problem. Many decisions, and that's what I was hearing when I came into the room, many decisions are decisions based on administrative discretion, eventually even ministerial discretion, with little review possible, except judicial review, which is always hard to obtain because you have to go, you have to have a counsel, you have to have interpreters, etc. And also it's not a review of the facts. Judicial review is about errors of law. Most of the decisions taken about migrants are decisions of fact. I don't believe you. That's a decision of fact. It's not reviewable really by any court of law. So there's a problem. There's a problem of capacity to access, and there's also a problem to have a lawyer. Most of the migrants I've met in detention have difficulty talking to a lawyer. If you're detained in Yonga Hill, the lawyer has to drive for an hour and a half just to come to see you. That doesn't happen often because that has a cost, and that means 3 hours just for driving. It doesn't happen. So access to lawyers, legal aid programs, which existed in the past, have been taken off the table. Access to information, access to civil society organization when you're in detention, very difficult. Access to civil society organization in Nauru, very difficult. They're not necessarily welcome. So no information, no counsel, no legal aid, capacity to access justice is extremely limited. And I think that comes from years of teaching constitutional law. The more you have administrative discretion, the more judicial review you need in order to ensure that the space for administrative discretion, which is necessary in government, is not clouded by suspicion of illegitimacy. You need judicial review to ensure that systematically decisions taken can be taken to court effectively. And when governments accept that and think about it in advance, very often we see that maybe 10, 15, sometimes 20% of decisions will be struck down by the courts. But that means that 85, 80% of the decisions will be validated. Most of the decisions taken by government will be validated. And that, to me, is a very positive income for any governmental authority. And that would be the next element. I think what is missing in Australia, and that's a conversation I've had with Mary Crock for many years, what is missing is either a constitutional Bill of Rights or a legislative Human Rights Act, which would allow everyone, all Australians and all foreigners under the jurisdiction of Australia, to test the validity of any law, any policy, any decision taken, which may affect their rights. And again, this is a legitimacy test that will run in favor of government for most of their decisions. And I don't think, unfortunately, that politicians always see that. There are many other issues in the end of mission statement that we could talk about. If you look at the end of mission statement, it's now made public. I have a section on non-refoulement, one on complaints against abuse in immigration detention and RPCs. I have something on guardianship system for unaccompanied children, something on family reunions, something on visa refusal and cancellations, on access to citizenship, on the Border Force Act, on labor exploitation, on xenophobic speeches and acts. So these are other important issues. I won't go into detail. I'd rather have a conversation with you. One last thought, which is not in the end of mission statement, I reserve that for the report, but it will be in the report, is international cooperation. I think that several countries, including Australia, from what I've gathered, understand now, that was not necessarily the case 5 years ago, understand now that control of immigration and international migration governance cannot be done alone. That migration movements will occur. We are a migratory species. That's in our DNA. It's not going to stop because governments decide so. Migration cannot be stopped, but migration can be governed. And not one single country can do it alone. Therefore, if we are to govern migration, it will be through regional cooperation or global cooperation at different levels. This is what I think has developed at a global level since the first high-level dialogue of 2006, through the Global Forum on Migration and Development, the second high-level dialogue in 2013, and now we have the global compacts that are coming for 2018. I think there is a realization that migration governance has to be cooperative, and we have to work to solve migration governance issues, and that trying to stop migration movements simply is not sustainable. Target 10.7 of the 2030 Agenda on Sustainable Development, states have committed to facilitating migration. Now, facilitating in English, or in French, the other language I know of, same word, means making easier. That's not exactly what we hear politicians say, but that's what we've all committed to for the next 15 years. And so I think that one of the challenges that we were going to face in the coming years, for example, through the negotiation of the global compacts, is can we think of the global compacts as a first step towards making mobility easier, facilitating mobility, offering more options for legal, safe, affordable, accessible mobility solutions. And that would go for asylum seekers, for refugees, for temporary migrant workers, for people, facilitating migration and mobility and facilitating integration for ourselves as well as for others. And to me, this is the kind of project we can put, for example, in an agenda. We could have a 15-year agenda for facilitating migration and mobility, like we have a second Sustainable Development Goals agenda. And I think that countries like Australia, like my country, Canada, many countries in Europe, could take a leadership role in doing this. And I think that many, for example, middle-income countries, I think of Indonesia and Malaysia in this region, but Brazil, Argentina, Chile, and Latin America could play also a leadership role in doing this. And for me, there's a challenge here to change the attitude from let's stop the boat now to what can we do in the next 20 years to make all this work better for ourselves and for them. I'll stop there.